Hello everyone, I'm Dwight Mitchell, the founder of Family Preservation Foundation and the Executive Director. Welcome to our Child Protection Services Pro Se Health Kit video series. I hope you enjoy the content and it allows you to better understand your rights and options while you're involved with CPS. After a 22-month battle, I successfully defeated Dakota County Social Services in Minnesota State Court pro se and had my children returned to me. Although I was filled with anguish, it was an education to say the least, and I will be passing on the benefit of my knowledge and lessons learned while cross-referencing Minnesota State statutes and case law, which is readily available on Google Scholar. One of the main reasons I decided to do this educational series is that, like so many other parents, I was not properly represented. Dakota County Social Services basically ran roughshod over me, violated numerous constitutional rights in the handling of my case. I currently have a federal case before the 8th Circuit District Court, and I've also filed a case for Family Preservation Foundation to try and change these unconstitutional practices in Minnesota. One of the things that disturbed me while putting together this series and while using the Freedom of Information Act and looking to see why we have so many issues with our system was when I wrote to the judiciary and I said, you've taken about 7,000 children a year every single year for the last 20 years, approximately. I said, how many of these parents in the last 5 years have had attorneys during the EPC hearing or the Emergency Protective Hearing? And I learned only 1,000 out of 1,000 parents actually had attorneys during this time period. And I said, okay, then during the admit-deny hearing, how many have been assigned attorneys, public defenders or, or even private attorneys? And the number only went up by a factor of 2. So only about 2,000 parents were represented. And I'm looking at these figures and I'm saying, so you're telling me that 5,000 parents, approximately 5,000 parents annually go through this entire horrific CPS process completely unrepresented, where CPS is running roughshod over the parents? And the answer to that is simply yes. So the goal of the video series is to enlighten and educate parents. I need to tell you first and foremost, I am not an attorney. I am not licensed to practice law, nor am I providing you legal services. I had to do a lot of training and education for myself as I was fighting for my own civil rights and for the return of my children. I recommend you obtain your own attorney if possible and view my training unit on working with your attorney. It will be worthwhile. This is a very important unit in our series and will assist you so you will not be misguided like I was by your attorney's legal strategy, because every attorney has their own strategy and it can be right, wrong, or indifferent, but you're paying them to represent you and they're using whatever strategy they see fit, and it could be wrong and lose you your case. Or you can have an incompetent attorney, or you can just have a greedy attorney. So you need to understand how to interact with your attorney and how to work together to win your case. You have the details and the facts relating to your case. Your attorney has the legal experience. Between the two of you, you should be able to be successful against CPS. So, as I said, this video series is for educational purposes only. I will look over the beginning, the middle, and the end of the CPS process and what you can do in your defense against CPS. This is going to be hard work. There's a lot of reading involved. There's no getting around it. Nothing worthwhile in life is free. You're fighting for your children and your family. Just knuckle down, stop complaining you can't do it. Anybody can do it. You just have to read, take your time, and you're fighting for your family. The Minnesota templates that I provide or the examples I provide are examples only, and they're not to be used as is. Everyone's case is different. Just like my series, Working with Your Attorney, I have like 4 or 5 different sections. If your case is about abuse, if it's about neglect, if it's about drug use. So there's different dynamics in every single case, and so you really have to understand the pros and cons as you're moving forward in the process. The purpose of this training unit is I call it Minnesota CPS 101, which is the timeline. And so there is a timeline of 12 months, and there's a number of things that are supposed to take place at set intervals along the timeline, and there are a number of things that must be done and presented per state statutes. Your job is to make sure that these things are done according to the timeline, and that anything that's required of you for your defense is properly submitted in time and is readily available for the judge to read. So the purpose is an overview of this 12-month timeline, how to calculate the 12-month timeline and when the clock actually starts ticking on this timeline, key events along this timeline, and legally permissible options for extending the timeline. Sometimes the timeline can go over 12 months, but there needs to be extenuating circumstances. So the purpose of the 12-month timeline was adopted in 1997 by the Adoption and Safe Families Act. It set a 12-month permanency timeline to ensure courts did not allow children just to linger in foster care one day more than necessary. Trauma and ongoing instability can lead to an unhealthy development, oftentimes leading to delinquency and criminal acts. The statistics on foster care outcomes are abysmal. If you look at the statistics that are put out by the federal government, within 2 years of aging out of the system, at the age of 18, most foster care children are either homeless or in jail. It's just horrific. 75% of the children, 75% of the prisoners in jail were former foster care children. 85% of the prisoners on death row were former foster care children. In my humble opinion, it's like a foster care to jail pipeline, and the federal statistics back it up. I don't understand why things aren't changing. I have my own personal opinion, and I think it's relating to money. But this is a perfect example of Einstein's theory of insanity, to keep doing the same thing again and again and expecting different results. I have statistics going back 10 and 20 years as it relates to CPS. I focused most of my findings on the last 5 to 10 years, and nothing has changed. The statistics hasn't changed. About 6,000 to 7,000 kids go in, 6 to 7 come out. It's like a revolving door, and the foster care outcomes are the same. So the system knows and understands this trauma is going on, yet they're allowing it. But let's get back to the topic of this training unit. I don't want to digress. So what you need to understand is that this 12-month timeline starts that the child is actually placed into custody, court custody, and it has to be by a court order. Now, you can have an emergency situation where the police might remove the child for a 72-hour, security hold. Well, it doesn't start on that day. The day you go to court, and when you get that first court order placement with a non-residential parent, or the child is put in foster care, that's when the clock starts ticking. It includes orders for custody or ex parte emergency protective care. If the CPS goes to court and gets a court order and says we want to remove this child today, well, the clock starts ticking on that day also. It also starts 60 days after a child is voluntarily placed in foster care. Say a parent is having a hard time and they can't handle their child, and they, say their child is in need of protection or services, and they voluntarily place the child with CPS. Well, then 60 days after that, the clock starts ticking, because CPS is trying to get things sorted in the first 60 days. And if they can't get things sorted between the child and the parent, then this clock starts ticking if the parent voluntarily says, I need services and I want to place my child with social services. So what days count toward the 12 months? All days that the child is in protective supervision with a non-resident parent. So all days in a home of a non-resident parent or a foster family, all days in a trial home visit, all days in court-ordered foster care or home of a non-parent in the last 5 years, if there's a prior petition. So it's cumulative, starting from, the last day it ended. So if you're, looking at the timeline, which you should be seeing right about now, this is what your basic timeline looks like with the key events along the timeline. There's also a PDF version of this timeline along with the handout, so that you can have just the timeline with the key dates on it for easy reference. So this is what your 12-month timeline looks like. Your CHIPS proceeding is in the first half of this timeline, and that's in the red box. Your permanency proceedings are statutory in nature, so there's a number of things that must happen in the first 120 days in the CHIPS proceedings, and that's the key dates we're going to focus on along the timeline. So the very first date we're going to focus on is the child removal from the home. So that's day 0. Once the child is removed from the home, the clock starts ticking, and a number of things must happen based on Minnesota statutory requirements. The child can be removed by law enforcement for a 72-hour police hold. If they get an emergency 911 call to the house and they see that the child is in a dangerous situation, they can remove the child and place the child on a safety hold to see if there needs to be an assessment. The county can actually do it. A social worker can go get an ex parte motion for immediate custody. It's called emergency protective care. That's when they get a court order from the judge to go to your house, give you the order, and say, we're taking your child out of the home today. The 12-month clock starts with the court order placement, or as I said before, the 60 days of voluntary placement. The next key point on the timeline is the next 90 days, or the next 3 months. 3 days, not 3 months, 3 days. In 3 days' time, you're supposed to have an emergency protective hearing. So in the emergency protective hearing, it must commence within 72 hours of removal. They have to issue you a summons, and a petition has to be served on all the parties and participants and attorneys within this 72-hour time period, and everyone has to show up at court. The purpose of the EPC hearing is to determine whether the child can safely be returned home or must be continued in protective care. Parents, attorneys should be present at the EPC hearing, and they should be presenting all of their evidence to show why the child should be returned home is in a safe setting. If you don't have an attorney and you go to the EPC, you must be able to present your evidence. You can call witnesses. You can have doctor's reports. The county is only allowed to show a prima facie determination, and what that means is they received an allegation. The allegations said X, Y, and B. These equal abuse. And if these, in fact, are true, the child is in need of protection or services. Your Honor, we want to hold on to the child for 60 days until we go to trial to determine whether or not these allegations are, in fact, true. The findings and decision by the court, as I said, is a prima facie determination. Unless you can counteract that prima facie, if they say the mother's a drug addict and you come in with a drug test that you took that day that says you've never used drugs in the last 10 weeks, well then, that cancels out the prima facie that the mother's a drug addict. If they say the mother is psychologically imbalanced and you have a doctor from a psychiatrist that says the mother is sane, she's able to parent her child, there's nothing wrong with the child, that cancels out the prima facie. So these are the things that the judge looks for in the EPC hearing. He looks for endangerment, and he looks for the EWA rules for children who are of Native American descent. Other decisions that are made at the EPC hearing are visitation, the identification of relatives, if the child is to be placed with a relative instead of going to foster care, because that is one of the things they're supposed to do first. They're supposed to look at placing the child with a relative over a non-relative. They will do an assessment on medical, chemical health, mental health, parenting capacity. So if all of these things are come into play, or if these allegations are in play, your job at the EPC is to bring in evidence to refute or to cancel out the allegations, to show proof, that these allegations are not true. The next day that we're going to look at along the timeline is the admit-deny hearing. And the admit-deny hearing generally happens within 10 days after the EPC, or within 2 weeks. Sometimes it can extend out like a day or two, but it's generally within 10 days of the EPC. That's where you come back to court again, and the judge will ask you to admit or deny whether or not the allegations are true. Of course, I recommend, my humble opinion is that you always deny and allow them to prove something is the case. Never admit to anything. It is their job to prove that you are guilty. It is not your job to confess or to help them with their investigation. So sometimes the admit-deny can be combined with the EPC hearing. If you're acting pro se, I would say to never do this, to always push it out to a separate hearing. This gives you a chance to put in a motion to dismiss. In Minnesota, the only time you can put in a motion to dismiss is before the EPC. I mean, you can put in motions to dismiss along the timeline if you find other things that have not come to pass, but it's definitely more difficult. The state statute says a motion to dismiss has to be entered before the EPC. So that is something to look at as to why you always want to have a separate EPC hearing, and not to, a separate admit-deny hearing, and not to combine it with your EPC hearing, which happens on day 3. If it's an Indian child, they can't commence any proceedings whatsoever until the tribe and the parents have received notice. So if you're of Indian descent, that is something to keep in mind also. The purpose is for the parent who is the legal guardian to admit or to deny the allegations. Around day 28 is when you will have a scheduling order. Of course, if you deny the charges, then you will have a hearing. So now you're on day 28 of day 60. By the 60th day, they are required to have a trial to present to the court evidence that you, in fact, abused your child. So that, and I tell everyone, it's their job to prove the allegations. They have 60 days. You'll be going back and forth so many times in the first 30 days that even though it's very, very difficult, I wouldn't admit to anything. I'd let them prove the allegations, and they have 60 days to do that. So once they do the scheduling order is to schedule the trial. And this is what people need to understand. The trial has to happen in 60 days, but there are a number of things that are supposed to happen in this 60-day time period. So you have the scheduling order to ensure key dates along the 12-month continuum are specified as a reminder to the parent and the judge, the county attorneys, and everyone else. So the timing is there. So it must be issued in every CHIPS case. So by the 28th day, there should be a scheduling order which includes, the date of the trial. The scheduling order must be issued at or within 15 days of the admit-deny. So if the admit-deny happens on the 13th day like it's supposed to, then that scheduling order should come on the 15th or the 15 days later, which is on the 28th day after the proceedings have started. It must be stated, and it must be, on the record, on the court record, and it must be in writing. So please, keep that in mind also. The content of the scheduling order will address pretrial hearings, the trial, the case plan, permanency progress, review hearings, date for permanency petition, the admit-deny, or a permanency petition. So every single date is scheduled from the 28th day that your child is removed from the house. And so when I say the first thing it talks about is pretrial and trial, and that trial has to happen within 60 days. That's what you should be working on. And if your attorney tells you to cooperate or to admit to anything or something of that nature, you need to find another attorney right away, because that attorney is supposed to be fighting for you to prove your innocence. It's an adversarial relationship. The county and the county attorney are trying to prove that you're guilty, and your attorney should be trying to prove that you're innocent. There is no cooperation. There is no, working with CPS to give them the evidence to find you guilty. He should be telling you, don't take your analysis, don't go to their doctors. The only thing you should be doing is visitation. And if they're not telling you all these things, and if he's not preparing to defend you in trial, then you need to get another attorney. So on the 30th day, the county is required to put in place, it's what's known as an out-of-home placement plan. Some people call it a case plan. That case plan is what social services says you need to do in order for that child to safely return to your home. Well, you don't have to agree to the safe plan, and you definitely don't have to sign it. They're going to try and make you sign the case plan. You do not have to sign the case plan. You do not have to even do the case plan. You don't have to acknowledge it. They can send it to you and send it to your attorney, and you could say, yep, that's fine, but until I'm found guilty at trial, I don't have to do anything about this case plan. I don't have to worry about it outside of my visitation with my child for 2 to 3 weeks, 2 months. I'm sorry, not 2 to 3 weeks, 2 months. That's the only thing you need to be concerned about. And you should be able to see your child, a few times a week. And if you're not seeing your child a few times a week, you need to bring that up to the court and the county attorney and make sure that happens. But that's the only thing you're required to do during their investigation. So I don't think there's anything else I really need to say on the case. But I was trying to determine where to go. The case plan is a little difficult for some people, because a lot of people think that if they comply with the case plan, it will help them get their child back faster. It does not. As a matter of fact, it does the exact opposite. It opens the door. It gives the county more ammunition to say you weren't visiting your child, you weren't complying with the case plan, it just gives them more ammunition to say negative things about you. If you're not doing the case plan, and if you're visiting your child regularly, then they're going to have to prove at trial in 60 days the allegations against you. So, please keep that in mind also. The next thing along the timeline is the pretrial hearing and then the trial. So if a parent enters the denial, which you should, my recommendations, I'm not your lawyer, you got to listen to your lawyer. Pretrial must be held at least 10 days prior to the trial. And a pretrial hearing is an opportunity to settle or narrow the issues down. And when I say settle, you never settle. There's nothing for you to settle. They need to prove that you're an unfit parent or your child is in need of protection or services. So, when they say settle, I'm not quite sure really what that means or why they say that, but that's the context of the pretrial. And then it helps you narrow the issues. So if Child Protection Services are saying we have 10 things, but they've only collected evidence for 2, well, then they're not going to try and talk about 10 things that they don't have evidence for. They're going to try and narrow and say, here's the 2 things that we're going to focus on, and we're going to be looking for the parent to cooperate, or this is what we're going to be trying to prove at trial. And you're going to be like, great, and we're going to be trying to disprove this at trial. And that's what you and your attorney should be doing. As I said before, the trial must commence 60 days after your denial. So if you have an admit deny on the 13th day, 60 days after that, you should be having a trial. No more, no less. If they tell you otherwise, you can write to the court, write to the judge. These are the statutes, they're a requirement, and actually it should be set in that scheduling order. So the minute you get that scheduling order, in the very beginning, if you don't see that trial set, the pretrial and trial set for 60 days after, you could say, excuse me, Your Honor, I'm looking at the scheduling order, and my trial is not set, or my pretrial is not set as it's supposed to be. Can we discuss this? Is there a mistake or an oversight? And if so, can you please correct it? The trial must be over within 30 days and 30 consecutive days. So if it starts on the 60th day, that trial should not go over 30 days. And if it's a 30-day trial, that's a very, very long trial. Most trials are a few days. They're under a week. There can be adjournments where they can say, well, we need a day. We need to take a day off here or there. But the whole process needs to be finished, and the trial must be continuous, unless there's an emergency. That's what I was talking about, an adjournment, where a lawyer gets sick or something of that nature. So it has to be over within 30 days, and it should be continuous. The judge will either grant the CHIPS petition and say, okay, the child stays with CPS, or they're going to dismiss the petition and give you your child back immediately that day. So the next thing we're going to talk about on the timeline is adjudication. Adjudication can be one of 2 things. If the parent admits that they abused a child, or if at trial the county meets its burden of proof, the court will adjudicate the child to be in need of protection or services. If the county does not meet its burden of proof, if they cannot come forward with the evidence, the court will dismiss the case and the petition and, as I said earlier, give you your child to come back to go home. The next thing we're going to talk about is the interim disposition review. So if the child is adjudicated and has to remain in CHIPS care, it is mandatory that there's a review hearing in 90 days to see if you are in compliance with your case plan. There can be other motions going on at this time by your defense attorney to try and get the case dismissed if new evidence comes to light, or if you're working your case plan exceptionally. But that happens at least every 90 days. It's more frequent if there's chemical or mental health issues. They might have it every 30 or 60 days because they want to see if it's, especially if it's chemical, if you're doing better, like if you've stopped taking drugs or gone to rehab or whatever the case may be. So the purpose of the interim review hearings is really to review your progress. They found you in need, they gave you a case plan, and so they want to see how you're progressing with the case plan. The judge wants to see how you're progressing with the case plan. It's reviewing the services provided by the agency to see if there is something more that the parent needs to help them be successful to get their child back. If there's something about the case plan that the parent doesn't doesn't care for, and you need to speak up about the case plan also. If it's going to interfere with your work or something of that nature, you can't do it. I knew one member who they were making drive to have a UA test done twice a week, an hour away from their house. And I'm like, I asked her, frankly, why she didn't say something, and she thought, why? I thought I had to do it, and if I didn't do it, they thought I wouldn't be in compliance. I said, that's unreasonable. I said, you're working full time, and you have to drive, an hour each way. These are things you can talk about. So, please keep that in mind as you go forward also. It's also set to review the well-being of the child, medical and dental, eyes, education. It's looking for relative identification. It's looking for reports from the guardian ad litem and the social worker. These reports, as I said before, must be filed, 10 days in advance. You should receive a copy at least 5 days prior to the hearing, so the parents have time to review and discuss it with the child. If you do not get that court report and recommendations from the guardian ad litem and the social worker prior to 5 days before counsel, either you or an attorney need to reach out to both and say, I need the court report that you submitted to the court, or you can go down to the courthouse and get a copy also. So that's something else you can do in that regard. The next key date along the timeline we're going to talk about is the Permanency Progress Review hearing. This hearing should happen no later than 6 months after the child has been removed from the house, or 180 days after the court's ordered placement of the child in foster care or in the home of the non-resident parent. It's required for all children in foster care or in the home of a non-resident parent, regardless of the child's age. It used to be for children under 8, but it's no longer for children under 8. It's actually for all children at this time. So that is one of the things he's going to be reviewing. There's a permanency, progress review hearing. The court must review and make findings on whether the parent is making adequate progress as it relates to the OHP, or the out-of-home placement plans, commonly known as case plan. They're going to be looking to see if the parent is making regular contact with the child. Is the parent doing visitation? Is the parent is the child benefiting from the ongoing relationship with the parent? Something that sometimes confounds me, but is the agency providing the necessary services and or reasonable or active efforts to ensure the reunification of the family, because there should be a reunification plan also. So the judge needs to make a determination on whether to proceed to permanency immediately, meaning termination of parental rights. And permanency means the parent hasn't been coming to see the child, the parent hasn't been doing the case plan, the parent's not doing anything that CPS has asked them to do. Well, then the judge could say, well, let's just go to permanency. Or if the CPS comes and says, well, things are getting a little bit better, we just have one thing that we need the parent to work on a little bit more, we'd like to ask for an extension. The judge can grant an additional 6 months to work on what the parent needs to do, which brings us right up to after that next 6 months, so to speak. If they don't terminate the parental rights right away and 6 more months go by, well, that brings it up to the year that I was talking about along that 12-month timeline. And within at that 12th month, what the court must decide at that time, based upon the recommendations by CPS, of whether they're going to transition the child back to the parent, give the child back to the parent, where they're going to put in a petition for the termination of that parent's parental rights, where they're going to put the child up for adoption, where they're going to put the child with a relative. Is the child going to remain in foster care? Is it going to become a ward of the state, meaning the state has to take it over and take care of the child? So those are the things that happen at the 12th month. So if a permanency petition is filed for the termination of parental rights, if it's involuntary, the parent is presumed to be palpably unfit to parent the child, so that CPS will remove the child permanently from the home. Sometimes they'll do what's known as a CHIPS bypass, and I'll discuss that later on in the next unit. What a bypass is, that's if someone has already had their parental rights terminated and they have another child. Well, that child's rights get terminated also, and that's called a bypass. So I go into more of that in detail. A lot of people will call and say, if I lost my child to a TPR in the past, can I lose, my new unborn baby? The answer to that is unequivocally yes. They will be sitting in the hospital taking your child the minute the child is born. I have had about 25 parents not listen to me, and then they call me afterwards when their child is taken, and I tell them, here's the statute, here's the law, here's what they're going to do, and sure as shooting, CPS is in the room right after delivery taking control of the child. So that's called an expedited permanency proceeding, and so that will take place. So at the permanency petition, the burden of proof switches, and the parent now must rebut or refute the presumption of palpable unfitness and prove that circumstances have changed and that they have the capacity to parent the child. Theoretically, what the court or the law is saying, well, we've given you a year to turn your act around, and you haven't turned your act around in a year, so you're unfit to be a parent, and we're taking the child. Now, the parent must come back and do everything to show the court it has changed, what it has done, the classes it's taken, and whatever else it needs to do to show that they are fit to parent their child. If the TPR is voluntary, if a parent says, I'm never going to get it together and I'm voluntarily terminating my parental rights, and it's not expedited because it's a newborn child, they can transfer permanent legal and physical custody to a relative, or they could, put it in foster care. They can put the child up for adoption. So there's a number of things that can happen if the parent voluntarily does a TPR. But none of the parents I know in my group has done a voluntary TPR, and so I'm not going to really dwell on that, because this organization and this group is more about defending parental rights and family first, and it's the 6,000 members we have in our organization at this time. They're all about that defense. So there is the possibility, as it relates to permanency, that the child can be put in long-term foster care. That's if they can't find anyone to adopt them. This generally happens with the older children. The younger children are easier to adopt. So, these are some of the dynamics, and I'm not going to really go into detail, because of, people are voluntarily terminating parental rights. You still have to go through another trial on a termination of parental rights, and this is where, here again, once again, you need a good attorney, because you're about to lose your child, and one who's used to fighting CPS. And with that in mind, that's what takes place after the 1-year timeline. So here again, you have another admit-deny hearing. You need to admit or deny the child is safe to return home. The court must commence the admit-deny hearing no later than 12 months after the child has been put in out-of-home placement. If you deny that you're unfit and that you want your child to come home, the trial must start by day 425, which to me is a little long, considering the child's been out of home for 365 days. Now it goes to 425 days. Here again, it must be over a 30-day period, and it must be consecutive. And it must be sooner than 445 days that the child has been out of home placement. The court has 15 days to issue an order. It may extend that up to another 15 days if there's, extenuating or mitigating circumstances that they have to try and analyze and understand, what's going on. You can extend the timeline by, if you're a parent and say it's at the 12 months and they're trying to do a TPR, you can extend up to 6 more months. But, you have to get approval. You have to show that you're working, things are changing, you're in school, you're doing some sort of counseling or something. You just need more time. But here again, there must be proof. You have to be showing that there's an ongoing effort, not at 12 months, okay, I'm going to decide to start doing this now. At that time, it's a little bit too late. They still have to prove you're unfit, but you haven't done anything to show the court otherwise since the child was adjudicated CHIPS. So they're going to, I can't say assume, they're going to find it very difficult to favor you. And that's just, my humble opinion. So, as I said, if you've made substantial progress in the case plan and you're doing, what the social workers say, the social workers, and you're demonstrating a capacity to care for the child, you're doing home visits, you're doing out-of-home placement, the CHIPS CPS can recommend that they extend it 6 more months to allow you the opportunity to continue because you are doing well. So the 12-month clock actually doesn't stop. They just give you extra time to work on your case plan, hopefully so you can get your child back. So, your goal is to try and get like protective supervision if you're a parent. You're trying to get the child returned home under supervised capacity. You're trying to get legal, some sort of legal physical custody back. There really is no time limit. The court jurisdiction continues during this extended time period, and there still is regular monitoring of the parents and the children to demonstrate that the parent can safely parent the child. So if they feel that things are not going well, then they'll put in that petition and they'll say, no, we want to proceed to permanency unless there's some compelling reason, and then the court will generally take CPS's recommendation and you'll end up going to trial. That is pretty much covers that 12-month timeline and the extending of that timeline. There's more information in the handout that goes along with this. I recommend you read it 3 or 4 times to understand your timeline and what's due during that time period as you go through the rest of the units, rest of the training units. It'll give you a thorough understanding of what needs to be accomplished and when. In closing, I'd like to leave you with one piece of advice that I leave at the end of all my training units. Do not believe anything that anyone tells you unless you have read the Minnesota State statutes yourself and the case law, especially anything told you by the state or county officials, which includes the judge. Make them show you the relevant statutes that they were referring to, just as I will throughout this entire series. So if someone is contradicting the statutes that I've given you that you've seen, then they have to show it to you. Once again, thank you for attending this training session. I hope you've gotten something out of it, and good luck in moving forward with your defense against CPS.